To be or not to be? That is the question. This old sequelae from the William Shakespeare play Hamlet helps me pose the question: to be or not to be, an amateur or a professional? Amateurism and professionalism tend to meet at a crossroads when collegiate sports are the topic. In the last 2 years, the National Collegiate Athletic Association has changed their stance on what is amateur play and what is professional play. In an Iowa Law University note on maximizing benefits for players, the NCAA previously described amateur athletes as those that did not get paid. Their fear was that pay-for-play schemes would arise or college programs would lure players with the promise of additional benefits to sign with their programs. As of 2021, the NCAA has allowed players to benefit financially from their name, image, and likeness, which is also called NIL. This new rule is in total opposition from the stance of the NCAA of recent that has historically disallowed any benefits from college athletes other than their scholarship, meal plan, room and board, and a stipend. As an avid college sports fan, I am aware of the penalties that have been rendered for violating the NCAA rules. A university in Texas was given the death penalty in 1987, which canceled their entire season, and their program took years to recover. How did the NCAA evolve to approving NIL deals among collegiate athletes? College sports was once unregulated student-led competitions that will often include non-student participants. Harvard College and Yale College were the first institutions to host an organized school-sanctioned event, which was a rowing competition. By the end of the 19th century, college athletics had become a profitable enterprise. This promoted the need for regulation and led to the formation of the NCAA. A court ruling involving the NCAA sided in favor with the definition of amateurism, stating, in order to preserve the character and quality of the product, athletes must not be paid. As college sports expanded and television contracts became a thing, the demand for collegiate sports grew, which would generate large revenues. Power 5 conferences such as the Southeastern Conference or SEC generate billions in income, billions with a B. Even with this being the case, most athletic departments report financial deficits. Two contributing factors to the deficit are the cost of coaching salaries and luxurious athletic facilities. These facilities are also a luring technique to get good players to sign with a particular program. In 2014, NIL benefits came into question on the state level when a former collegiate player saw his image on a video game after he was no longer a student. Another case that brought publicity and how publicity is defined under scrutiny was when a professional player sued to prevent his image from being used for a certain brand. NIL rights are in place to protect the inherent right of every human being to control their commercial use of his or her identity. Since 2019, California state legislatures have approved NIL rights and benefits for collegiate athletes. This opened the door for more states to follow suit. Since there is no federal legislation yet, the NCAA has not been able to regulate or deregulate NIL, and each state controls the maximization or minimization of these benefits. Of course, there are some inequities of how these benefits are being distributed, offered, and used, but as of now, this is a big step for collegiate athletes. There may be a future where college athletics will be considered semi-professional because if most are getting compensated, they may not be amateurs.